And we can cut this part out if folks don't want their business information out there. Anyone like to start? Yeah.
We go. David Tavaruka. I'm with CCV. I'm part of the Vermont System Colleges, mainly working for CCV. My job, I'm a controller. I'm an accountant. I run the business office of the college. Anything else we need to talk about? Starting up.
Well, David's also on our board.
Oh, yes, that's right.
Yeah. Thank you for being here.
Yeah.
Thank you. Anyone else would like to share? Jay has a message. I'll read it if that's okay. Jay, I use they, them pronouns. Jay's a dog walker, sitter, trainer. They're currently self-employed, working to make their business more established. That's great. Thank you so much, Jay. Asia or Ilom? And if you want to just pop it into, oh, Asia, here we go. So I'll read this. Asia Gallo, she, her pronouns. Business is still an idea, but wants to start a wellness business, looking to start out as a consultant for others in the wellness field to run logistics, client relations, marketing, etc. Is a UVM alumni. Thank you for being here. And Alum, if it's not possible for you to unmute, that's totally understandable. So when you feel comfortable, you feel free to unmute. But, oh, there we go. Go ahead.
I'm driving, that's why, sorry.
Oh, no worries.
Right now, it's still an idea. I haven't started any business yet, but I'm trying to start something. So nothing's set in stone yet. So I just want to get information of how to, yeah.
Great, thank you so much. That's really helpful, actually. So as we start this process, so Thomas will be able to tailor it a little bit more. So why don't we start, or let's kick it over to the law school folks, starting with Sean. Introduce yourselves, and we'll end with Thomas.
Hi there, I'm Sean. I'm a 3L student at Vermont Law and Graduate School, and I'm just going to be observing for today. So thank you for letting me in today.
Hello, I am Professor Jeannie Ikes. I am the founder of the Vermont Small Business Law Center, and I've been teaching law for 25 years. I've also run several small businesses myself. So this area and legal technology are my areas of expertise. And I look forward to answering questions after Thomas wraps up.
Hello, everybody. My name is Thomas Durham. I am a 3L student at Vermont Law and Graduate School, working on my JD, but also my restorative justice master's, which is actually what I plan to use. Here today to hopefully give everyone some good information about contracts in the creative sector. And just want to say thank you to Weiwei and the Vermont Professionals of Color Network for welcoming us into this affinity space to share this information with you. We really appreciate the opportunity to support small businesses in Vermont, especially those for professionals of color. And on that note, I'm going to go ahead and just start the presentation. I'm going to share screen.
Yeah.
Oh, is it not? Oh, there we go.
Yeah.
And let's see where.
And thank you all for being here. This is really meaningful.
Oh, thank you for having us.
Yeah.
There we go.
We're always excited to be here.
It's true. And difficulty, probably just give me a second. Where's my screen share for?
And bottom button green.
While we're waiting for Thomas to share,
there it is.
So you know, the resources that we are going to be sharing today that will be available, I'll make sure to have it in a follow-up email for all of you, including the PowerPoint presentation that Thomas is presenting right now. And to start off, like, Thomas, what are the biggest challenges when it comes to contracts?
Oh, that is an excellent question. I'm so glad you posed it, Weiwei. So as we're looking at contracts, these are just general things that come up. Starting off with what contracts are, just want to give a brief overview to get us started. Most all of us are familiar with contracts because they come into our lives with such frequency. If you rent an apartment, you have a contract. Every time you update your phone, you have a contract that you have to deal with. It's just an agreement, a meeting of the minds, a way for people, especially business owners, to protect themselves and establish a same page understanding for all of the things that they're doing in terms of with clients, customers, and so forth. So it's just an agreement is all it is. It's just an agreement up front, kind of to protect in case things don't go the way you would like them to. Having one, verbal or written. Having one's a good idea for almost all business interactions. And there can be a misconception about verbal contracts not being a thing or not being as enforceable as written contracts. If you've agreed to something verbally in terms of an exchange, say you meet somebody walking down the street and they have a sign out saying selling these puppies for so much, and you start negotiating how much you would like to pay for it as opposed to what they have listed, you're entering into a verbal contract. So as far as contracts go, it can be verbal, can be written. Reading one, what we mean to say here, or what we'd like to illustrate to everyone, is that if you read a contract, or if you sign it, you're responsible as if you've read it. So the courts have again and again come back to the idea of enforceability in terms of if you've signed it, terms and conditions, if you check the box, you are going to be held liable for everything contained within as if you had read it.
And understood it.
And understood it. I'm sorry, that's a very important part. Occasionally, Professor Ikes will jump in. I apologize, to make sure that I, as the student, am covering all the bases that I need to cover. So if you agree to it, you're bound by it. Negotiating one. A lot of times when businesses are starting out, there are a lot of forms and templates available online. A little bit of research will produce many examples of any standard and many different types of contracts. When you pull a contract off a template, a lot of times it's going to be boilerplate. It's going to have standard language. And you want to make sure that you're not resting there. A boilerplate contract is a good place to start. But oftentimes will not be form-fitting to your business, to the specifics of what you're doing. And it might leave areas of liability or risk because you haven't tailored it to fit exactly what you're getting into, especially within the creative sector, because that's going to be their IP issues, intellectual property issues, ownership of which and control of the ownership can be problematic if you don't have a contract that really protects the fruits of your labor, which is what this is all about. Moving on, getting it in writing.
Before we leave
please.
that, one last piece of this. Beware people who say, we'd never enforce that. It's just something so-and-so makes us leave in there. If you don't like it, mark it out and initial it, right?
Mm-hmm.
Or talk to an attorney about removing that and how to remove it from the agreement.
Please,
Wei.
Yeah, I have a question about striking things out and initialing. Like, what is the risk of doing that without consulting legal counsel when you're striking things out? Like, if it's something where you're like, I don't feel very comfortable about that, and you strike it out and then you initial it, could that have negative ramifications? Like, are they going to accept that? One, are they going to accept that? Two, will that have implications later on?
Go ahead, Thomas.
I was going to say, what little I can say to this is based on, I was in the military, and some training we got, or one of the things we did in terms of handling documents in the military was, if you would use a blue pen if you had to change a document, strike through initial and date to indicate there was the original. One of the issues you can get with the strike through is verifying the authenticity of the removal of the information. So if you're altering a contract in that way, there can be questions as to whether or not it's an above board alteration, I guess is what I would say. But I want to make sure I'm not giving that information. So if it's okay, I'm going to go ahead and kick it over.
What I would add to that, Wei, is there's always a chance if you strike something, the other person wants that clause in there, that it's no longer a meeting of the minds. It no longer makes a good contract because you're not in agreement. So before you strike, if it's a friendly contract, I talk to people about the clause and say, hey, do you mind if I remove this? I'm not comfortable with it. And we're constantly going to, in this presentation, come back to the idea of talk to people, have a meeting of the minds, really come to an understanding. Of course, you cannot strike things from, say, your cell phone agreement, right? We all have signed those silly things, and we all say, wait a minute, what does this mean? And how can they provide a link to something that changes and say I signed it in the past and change it in the future and I'm still bound by it? Well, that's a great question, and I'm not sure the law has fully come to an answer for that. So lots of pieces here where we're going to say, you know what, the contract is your documentation and your memorializing of a meeting of the minds. And what you want to do is, yes, feel comfortable striking out that clause, but maybe first feel comfortable reaching out and saying to someone, hey, I don't like that clause. Can we talk about it?
Okay, so
And
yeah,
sorry,
more like instead of going straight to trial, like maybe having a mediator, like
Yeah,
talk about it a
exactly.
little first.
Let's be human first, right?
Mhm.
And once we've gone through that process and we can't agree, well, then maybe the contract is in this sort of working relationship we're trying to get to here isn't going to work anyway,
Mhm.
right? So better you find out now when you're negotiating a contract or an agreement than after you're involved in the work.
much better. And actually, I really appreciate where you bringing up the this introducing this topic, because one of the things I wanted to say as far as the overview, and I'm remiss in saying this, is contracts are not just a protection. We're saying they're meeting the minds. One of the other incredibly valuable things a contract offers is preserving relationships. That's really what they're about, because if you have a disagreement, you don't want to lose like a valuable client. You don't want to lose, or even inside the business structure, you want to make sure you have a document that really clearly says everything that's going to happen. That'd be an operating agreement, which is kind of a contract. And so just bear that in mind. The contracts can seem daunting as far as your legal documents, but really the idea is let's just keep everyone good to go with each other. Also, thank you, because we're going to be talking about alternative dispute resolution later as well. So thank you, Wei, for that mediation negotiation. Getting it in writing and signed. This can be very important. We're going to keep coming back to how contracts are just a meeting the minds. We're also going to be coming back to the idea of just documentation and the idea that there are legal protections provided by contracts. One of the legal protections specifically that are just baked into the idea are just proving it's evidence that there was an agreement and an understanding of the agreement. So getting it in writing and signed helps to establish that everyone has that same page, clear understanding, and their signature is basically their attestment to understanding. So it's important to get it can be very important to get a contract in writing and signed. And on occasion, depending upon the nature of the contract or the business relationship, that can be, if it's not signed, actually a means by which that contract can be looked at as less protection or even invalid. All of which is to say, these are all designed to allow you to deal with, as you can see, expletive happens, stuff happens. So when things go south.
Before you jump in here, there's a question in chat.
Oh,
Yeah.
I did not see that. Please.
Jay is asking, would a text be considered a verbal contract that's in writing?
Ooh, that's a good question. Professor
The
Ikes?
law professor in me loves this question and
I'm
would
gonna
love to
punt.
see you answer it, Thomas.
I would say yes.
It is.
Yeah.
It's not verbal. It's actually considered a written
Yeah.
contract. If there's a text and it's offer and it's acceptance, then yeah, it's a contract.
Which is, I want to say what I would have said, but let's just go ahead and say
It's totally what you
thank
would have
you,
said.
Professor X, for that answer. Be careful about texting and making agreements. And we're going to go over some of this later as far as developing a good mental habit of distinguishing, if you're a business owner, between conducting business in your name and conducting business in the business's name. Because the whole idea of an LLC, which we'll come to in a little while, is to create that protection. And if you breach that level of protection, it can just complicate complicate your life and destroy the protections that the LLC is designed to provide.
And lawyers, like people in other professions, use acronyms much to our disadvantage.
Oh, yes.
LLC is limited liability company, just so you know, and that is a type of entity that you can become that offers some protection against liability.
And if you want some support in deciding which type of structure you want, the Vermont Small Business Law Center is a perfect place to do that. Just want to add
Absolutely.
that note in there.
We really like doing it. It's a fun, those are fun conversations, entity formation,
There.
or business startup. So some things to consider about or challenges when it comes to contracts. It's a very understandable instinct to try to construct a contract that catches all of the things that might affect your business. However, that can be a mistake. You don't want a 100-page contract for something for purchasing a bike off somebody on Facebook or Craigslist. That's just too much. So you want the contract to be specific, but you should resist the idea of being able to include absolutely everything that might go wrong in a contract. There's a fine balance that lawyers can help you reach between tailoring it to your business needs and keeping it broad enough to cover everything while being specific to exactly the things that you might be encountering within the normal range of business affairs.
And if you're feeling uncomfortable because it's not specific enough, oftentimes you can include something in a contract by reference, like a scope of work, for example, or a document that's an estimate that you've created.
And as you go through, like say you were to add that section to further protect your business and to tailor it to exactly what you need, you're going to be generating versions. It's important to make sure that you don't have too many versions out there because it can be confusing for courts to figure out which one is the version that's currently being enforced, which one is the one that currently everyone is agreeing on. So as you go through, you also want to make sure that you don't just have a lot of versions lying around. And as you update, maybe you keep them for your records, but maybe excise them for being in operable status or just having a bunch of, and make sure it's clearly documented what is the currently established and operating contract that you're using to run your business. Okay, next slide. Oh, please.
Yeah, and Jin Lee just joined. Just gonna read their chat. So Jin Lee has a business called Asian Style Home Style Cooking. Jin Lee, do you want to introduce yourself really quick? You're on.
Oh, sorry. Hi everyone. Yes, my name is Jin Lee Chan. I own a business called Asian Home Style Cooking, and I'm kind of revamping my business model, and it's going to start in a few months.
Congrats. Yay. Thank you for joining us.
Yes.
And feel free to
thank you for
yeah, absolutely. Feel free if you want to be off camera, that's totally okay. We're just having everyone do what feels comfortable. So stay on, stay off, up to you. And
okay.
Feel free to use the chat or pop in with questions.
Okay, awesome. Thank you so much.
Yeah, absolutely.
Questions encouraged, please.
Yeah.
That's why we're here.
Yeah.
So speaking of questions, what kinds of questions do we frequently hear from business owners? And we've kind of just touched on this as far as what can go in contract. Can I put X in an agreement? The answer to that is almost always going to be yes, because contracts are very flexible documents by design. They're designed to be kind of a plug and play situation. Now, not quite that. I don't want to make it seem like you could just go online and stitch them together. The idea being, however, they can be constructed to meet exactly what you need and to the level of detail that you want and or require. Effectively, if you feel comfortable with it, it's probably a good thing. And then if you don't know, you can always just consult a lawyer. And I apologize as a law student that we're probably going to be plugging consulting a lawyer a lot during this conversation. But when it comes to contract work, if it at all is causing you discomfort, it might be a good idea to talk to a lawyer about it.
Or if you lack understanding, I'd say that's the other piece.
Mm-hmm.
You can feel like you're being pushed to do something in a contract. That's a good sign that you want to renegotiate or rethink it. But additionally, sometimes you read a word and you're like, what does that mean? And ask a lawyer, right? We do offer the 10 hours of free legal service because you come across words like that you're like, I have no idea what indemnification means. We're going to cover that later, by the way. But, go see a lawyer. Go see a legal expert who can really help guide you towards that. Don't trust YouTube. There's some misinformation out on the web, as we may have guessed, right? So, much like trusting your Google doctor, don't trust your Google lawyer.
And
Go ahead, Thomas.
I struggle to explain indemnification. I'm probably going to struggle during this. So if it makes anybody feel any better. When is a contract unenforceable? They're going to be, so sometimes a written contract is necessary for certain amounts. If you're dealing in dollar amounts over $500, or if it's going to take longer than a year to complete, or if you're dealing with a piece of property, a contract like that would have to be in writing to be enforceable. Sometimes a contract will include things that just are not reasonable or rational. So say you have a contract where like you're letting a friend borrow your car, and if they wreck your car, it's written in the contract they owe you $5 million. That would probably not be enforceable. Most courts would look at that and just say, this is unreasonable. It doesn't really bear anything to do with the loss of the vehicle, the worth of the vehicle, and so forth. So not going to be enforceable. If you have questions, oh, please wait.
What would be enforceable in that scenario?
Car replacement, I would imagine.
Okay.
If it's within the realm of reason. So if the cost of the car replacement might be, I can't speak to the specifics of what exactly would be enforceable because there is some leeway with that in terms of the court's interpretation of enforceability. If you really have questions, a lawyer can help out with the specifics of a contract enforceability. But if it seems rational and reasonable, if it's something you would comfortably sign, it's probably within the realm of enforceability in terms of reasonability and rationality.
And this is where we get into some of that freely entered into as well.
Mm-hmm.
You can't be coerced into signing an agreement and have that agreement upheld. So a contract's going to be unenforceable in those instances. Also, if there was just a mistake, just a flat out mistake in the writing, or, hey, somebody added an extra zero to the amount that was owed, and that was an error. Those kinds of things are not going to be enforceable if it was just a flat out mistake. So there are times in which contracts aren't enforceable, and these are not tools of how to con someone, right? That's not what contracts were created for. They're created to help people understand both sides when they enter into an agreement.
So, and speaking of that, instances of fraud would negate. And as Professor Ike said earlier, if the meeting of the minds falls apart because there's been an alteration that both sides don't agree to, that can affect the enforceability of the contract as well. What should I have in my contract? Well, we have one of our faculty members of the Vermont. I'm going to try to get the acronym right here. Small Business Law Center, named Professor Goodenough, has this explanation he uses regularly called 4 buckets. So there are going to be 4 kind of different aspects, 4 umbrella aspects of a contract. The first one's going to be all of the specifics of the information, or all the specifics of the business and the deal that come from the business owner. This is going to be what the business owner brings in and needs to have in there. Who they're dealing with, the name of the business, what they're manufacturing, all the specifics and nuts and bolts of you and your business operations. The other 3 buckets are going to be the ones that lawyers can help out with. The first one of those is just protective provisions. An example of which would be indemnification, which we already kind of mentioned, which is kind of a hold harmless clause, or force majeure is like an act of God clause is one that's people think about. So in that one, let's say you have a contract to deliver 10 bicycles to somebody on a certain date, but there's a hurricane and all of a sudden the roads aren't navigable. A force majeure or act of God clause would basically say in that specific instance, we're not going to be liable for our inability to deliver the bikes. We're going to come back to this in a little bit, but COVID was another example that kind of affected or impacted people's ability to transact business as per their normal. And so that could also be something you could put into a contract to protect yourself.
We saw a lot of event planners with contracts during COVID where things went poorly because they didn't have a good force de majeure clause that included a pandemic, right? Because we didn't think in pandemics prior to that.
And so, okay, after the pandemic, we had that experience, and then I'm guessing people started to add that, but what happened after the flood? Because that's another force majeure, right?
Yes.
And so were people more prepared as a result of COVID?
Floods were kind of included in that. When we think
Okay.
force of nature, we think earthquake, fire, flood.
Yeah.
There's some basic sort of almost biblical things that we think about when we think about force de majeure. Pandemic oddly was not often included,
Right.
because it had been so long since we'd seen a global pandemic.
I see. Oh,
And just something as far as on the topic of flood insurance, something to look out for in like commercial leases is whether or not it's specifically exempted. That can happen. So just read your commercial leases and leases carefully. Speaking of which, do I need a contract? Now, I'm not just saying this as a law student, but the answer to that question is probably going to be if you feel like you do, you're probably right. Given that anything having to do with business operations, the more documentation you have, the better off you're going to be. So do I need a contract for with my vendors? Yes. Do I need a contract to lease this fleet of vehicles for my business? Yes. Do I need a contract for the space I'm leasing? Absolutely. Suppliers, what have you. They're just, once again, same page, same page, clear understanding, meeting of the minds. Can I separate out the scope and quote from the terms and conditions? Please do so. Terms and conditions are going to be just a blanket set of rules that apply to how you transact business with every customer walking through the door. So they get the little box to check, understanding that these are specifics of how you do business. The scope and the quote.
For example, on that, I
yeah.
agree to pay in 30 days or whatever.
Yeah.
Right. Standard things.
Thank you. I was remiss in not including an example. I've been meaning to do that, but I'm getting caught up in the. Anyways, the scope and the quote are going to be, those are going to be specific to each client interaction, each customer interaction. So a purchase order is going to differ every time depending on what a prospective client wants to purchase, how many and what their delivery needs are and so forth. What kinds of contracts do I need? There are every flavor of contract that you can imagine for all of the different disciplines of business, all the different sectors, all the different things people do in terms of exchanging anything in which one person is providing something and the other person is paying for it or bartering or giving something in exchange. So contracts, if you can think of it, you can probably construct a contract to deal with the interaction. And so as far as kinds of contracts, there are a bunch. What if I decide to not have it in writing? Can I enforce that? Yes, you can. It just becomes potentially more difficult and complicated to enforce it. Because really with a written contract, what you're doing is pinning down the specifics so that as time passes, it's always clear what it was that was being exchanged, what it was that was understood between the parties about what was going to happen, who was doing what, and who was responsible for what.
Let's do a quick little role play, Thomas, for people to
Yes.
help illustrate this. So let's say all you had is a verbal agreement with me that I was going to deliver this bicycle to you. How do you go about getting me to address that I'm not doing that?
That's a very good question. I would have to go and look for any records I had, any notes I'd had, maybe my bank withdrawal related to the amount of money I took out to pay you, reference phone calls between us, text messages.
If we have a contract and you want to work through the situation, what's the first thing you do?
Read the contract.
And you send it to me and you say, here in this contract, we agreed to this. And it's written out and it's got both party signatures and there's no avoiding it. And it really helps avoid that last end of the line piece that we end up at, which is court, and nobody wants to go to court to resolve these situations. You want to be able to work it out between the parties, and contracts help you because they provide provisions for that for later.
Wait, you had a question?
Yeah, sorry. I have a lot of questions, everyone.
This
So
is good.
if you have questions, please jump in. So, because
We're happy to take them. It helps.
So in the case, I love that example that you just gave. So like in the case of, let's say, one of our business members having a contract with an outside party, and there's a breach of contract, and I think that comes up later as well in the presentation. But what if the other party is like, well, we can do this for you instead of what was agreed to in the contract? And because as the community of color, sometimes it's just easier to not have to go through the hassle of dealing with that process. I mean, that's kind of a big question, but what does the business owner have the right to do? Like if it's written in a contract, is it maybe get in touch with the law school and then like get some like legal assistance to enforce the contract? Or I know that's kind of a weird question.
No, I think it's a good question. There's just going back to my contracts class, it can be somewhat involved, I think, especially within the realm of merchantability or the was it the UCC, Uniform Commercial Code, about like supplementing or changing in orders and so forth. But as far as what the business owner has the right to do, you have the right to absolutely seek legal help, and then you could pursue alternative dispute resolution. But as far as people changing on things, actually, definitely want to see Professor Alex. What would you say? Yeah, I don't want to give bad information.
It begins with a conversation.
Mm.
And as much as we
Perfect.
might not like it, it begins with a conversation between the parties and say, hey, wait, we said this.
Mm.
And then arranging a time to sit down together and look at the contract together. Try first to work through it yourselves before litigation. Always, always. And then the step before litigation is always some kind of third party that can help you come together. And that third party, we talk about alternative dispute resolution and things of that nature. That third party could be agreed upon church elder, for gosh sakes. It could be anyone, right? Or a party that you both agree to that can read the contract and help you work through the issues. There's lots of alternative justice out there and alternative ways to resolve conflict, because all we're doing in a contract is trying to avoid conflict by laying out both sides.
Yeah.
And then if there is a conflict, we want to resolve that easily and in the most positive way possible. So the law is a tool to resolve that conflict and to prevent conflict.
Okay, that's helpful.
And that's what you're trying to do here is get to that place, right?
Yeah. And is there any difference between a contract and an agreement in terms of like terminology? Is it the same thing?
It's the same thing.
Okay, great.
It's the same thing.
Okay, let's see. So common mistakes made by small new businesses, not having a contract. As we were saying earlier, as I said earlier, if you're doing business, a contract is just a good idea. As far as, once again, what Professor Alex has said, lining out all of the specifics of the interaction, the business interaction that you're having, so that everyone knows exactly what they're responsible for. It can seem, once again, daunting to have a contract, but it's almost always going to be worth the effort, if nothing else, because it establishes that everyone, knows this is how much I'm going to pay, this is what I'm receiving, or let's say you're having something manufactured. These are the design specs, this is what it's supposed to be made of, and this is when I need it by. And then, as they said, when the vendor or the manufacturer signs off on that, everyone's good to go as far as saying we're on the same page and we can proceed as if everything's good to go. So not having contract, it's like insurance. It's one of those things, it's better to have it and not need it than need it and not have it. Not being specific or clear in a contract. Once again, going back to the idea of like too many specifics, that can be a bad thing. But here, what we're saying is, and he's kind of like boilerplate language might not, once again, protect all of the assets and business practices specific to your business. So if you aren't specific enough, it can create areas of liability, and that's just a problem. A contract, it kind of defeats the idea of having the contract. Not being clear can do the same thing. So any ambiguity, any parts that don't seem easy to interpret or that either side doesn't understand, that defeats the meaning of the mind's purpose that we're trying to do with the contract. And wait, I saw that you had a question, I think.
Yeah. And so Jin Lee put a question in the chat, and actually I have something similar. So Jin Lee asked, in terms of creating contract for folks renting her commercial space, is there a template that she should use? And who should I involve before creating a contract? And I was thinking about something, a similar question for Jay and Asia's example for the businesses that they're creating. Is there, because I remember from our last contract, and also Professor Ikes, you also said, don't Google lawyer it. Maybe that's not the best way to figure it out, but yeah, are there templates available for certain sector specific needs, for example?
Often there are agencies or associations that you go to that have rote contracts. So, for example, the Farm Bureau may have rote contracts for the purchase and sale of hay that they allow their members to have access to. And that's a starting point. And then you'd put your terms of a standard agreement into that. So professional associations or associations that have rote, what does rote mean? Standard.
Yeah. Sorry.
Go ahead. So I would look for associations that can help you. They generally are going to have the most often used, most accepted, most standard contracts for that type of whatever it is. If it's food service, I know like the food hubs have standard contracts that they work with for the kitchen piece, for commercial kitchen stuff. And if you belong to a food hub or an association in that food association, our agricultural center our food and ag center has standard agreements that they point you to for these sorts of things. So that's a place to get started. But then we offer that 10 hours of free legal service. After you've read through the contract, circle and highlight the pieces you're not sure of or the pieces you want to change and have that conversation with an attorney, right? So what you've done is you've gone in and you've prepared yourself in advance. You've said, this is what a standard contract is in my sector, in my industry for this particular thing. And now I want to take this to an attorney and get their feedback. And that way you've done both. Go ahead, Wei Wei.
So I'm also thinking about for sole proprietors. Because up to now we're talking about like LLCs, etc. So can a sole proprietor or solopreneur, whoever, also have contracts? And is it safer to have an LLC? Like for it to be on the contract?
I think we're going to get to that in just a minute.
Okay.
In fact, we are.
So if folks feel that their questions were answered here, why don't you go ahead, Thomas?
Oh, okay. Yeah, and we will have the Q&A session there, but that's an excellent question, Wei Wei. Actually, I see LLC on the screen. But the next thing we do want to go over real quickly is just not protecting, as far as common mistakes, not protecting or controlling intellectual property. One of the important things to think about, now intellectual property it sounds like a big term, kind of daunting. It's just an asset. For people in the creative field, you know what you're doing. You're creating something. You're bringing something to existence through the work of your mind and the work of your hands, and that is valuable. That's an asset, and that asset should be yours to profit from, to benefit from. So protecting and controlling your intellectual property is just a really good practice to get into, and you can do it in certain ways. Now, there are certain things that, like say somebody who writes a book, that's a work of authorship. something like a copyright would attach at the moment of creation. What we mean here by registration and licensing is there's a step beyond just copyright as far as the automatic attachment. You can take certain steps to register your intellectual property, your creative pursuits, things that you do that you're engaging in these contracts for, to further protect yourself. Basically, you're just saying, I'm going to let the government know what I'm doing, that I created this item, that it belongs to me, and that at such time as somebody tries to like imitate it or profit off it, and it's not you, you then have a greater ability to defend that creation and enforce a contract that might be related to the usage of it. So it's just a good idea to, and there are various different types of intellectual property. We'll come to this a little bit later. It's a good idea to register those, and licensing is another good way that you can maintain ownership of a creative product while allowing other people use, and then you still retain the ability to benefit and or profit from it. Go ahead, Weaver.
Is there a way to go a little bit more into licensing? Maybe in another, okay, are we doing another webinar? Do we do another webinar?
We could do another webinar around intellectual property, which is probably the right way to go for that.
Okay.
What I will say about licensing is it's a residual income, right? So I'll use the example Thomas and I talked about earlier this morning. You create this great new way to do a folding chair. And there's a furniture manufacturer in Vermont that wants to use your idea. You can license that idea to them, and you can do it in a lot of different ways. You can do it so that they pay you $1 per chair they make and sell, or you could do it that they pay you 25 cents per chair they make. They don't have to sell it, and you don't care if they sell it. You can do it so that every 6 months that they're using your idea, they pay you a set fee. There are a lot of different ways to handle licensing, but the important thing to note is it's a reoccurring income for you, but it's also, and this is maybe the most important thing, you could sell it to another company somewhere else who wants to create the same folding chair. And they have a slightly different spin on it. They want pink fabric on their folding chair and not blue like the other company is using, whatever it is. But it allows you to benefit multiple times through multiple sales of your design or concept, right? And that's what intellectual property is. It's that slightly ephemeral thing that we create in our heads.
So sorry to take us on a little bit of a tangent.
Please, please, it's good.
It's related. So, okay, I'm going to pick on Asia a little bit because she's talking about, consulting with wellness businesses, etc. If she were to say, and I'm just giving an example because this is what I thought of in terms of consulting, if there is like a plan, like a business plan that she's creating, is that a product that she could create a license for and then businesses could use it? Or like in what way could that be licensed?
It depends on the contract she has with the parties she's creating a business plan for, right? So if you agreed to sell that to them whole cloth, then it belongs to them. You worked with them to create it. And in a case of a business plan too, that's tricky because it's a lot of their intellectual property involved in that too. But it's quite possible. We had somebody at one point that did a certain kind of instruction for a new way to swim. And they wanted to have the ability to license it to various aquatic centers. Yes, you could do that, right? And you could say, this is my thing, and the step-for-step process and the guidebook for how to implement teaching this, I can sell you or license to you for your use. Now, could somebody else go out there, see what you're doing, copy it? Yeah, absolutely. And it would be really hard to enforce. So what you can license is that guidebook and the step-by-step process that you put together, right? And then you can relicense their use of a material, right? And so people who are in consulting positions often license materials or a packet of training or something of that nature that they provide.
But great question. And thank you for handling that for us. biggest mistakes on the back end that I see. Not having an LLC, a limited liability corporation, if there's some risk in the business. The reason we address this as a mistake is that the whole idea of forming an entity like a limited liability corporation is to limit liability, to draw effectively a legal distinction between a business owner and the business itself, so that, say, the business suffers some sort of financial hardship, creditors can't necessarily go after the business owner and take their car, their home, and other things.
Let's use
Sorry,
my
go ahead.
crazy chair example.
There we go. Yes.
Let's say you license the chair idea because it's a new way to create a folding chair, and lots of people manufacture it. And it turns out that people who are over 90 pounds, when they sit in it, it causes the folding chair to fold up on them. So that would be bad, and that would be a liability. And people who have a limited liability company instead of a sole proprietorship and have licensed it through a limited liability company, and that intellectual property, it belongs to the company, it means that folks can't come back on the individual. So you keep your house, you keep your car, right? Because they're not assets of the business. All right. And that's what a liability shield grants you. And so going back to Weiwei's question about, can a sole proprietor enter into contracts? Of course they can. Do they want to? Well, that contract for the chair plan, if they had entered into it as a sole proprietor, all of the risk would have been coming back to them. Okay. Instead of being in the company. Does that make sense, Weiwei?
Absolutely. And listen, y'all, we're trying to build generational wealth, not lose it. So let's go.
Absolutely.
One other question. Oh, yeah. So how do I start a small business in the food industry? How do I go about it, or where do I get resources that I need? Oh, that's yeah.
No, it's a great question. Actually, that's one of the questions we like to hear. I want to say, starting a business, it can seem daunting when we're throwing around terms like limited liability corporation. It can be intimidating. All of this is very easy to accomplish. It's actually one of the things, if you need 10 free hours of legal advice or just a consultation with the Vermont Small Business Legal Center, we'll happily provide. But the process of starting a business can be as simple as just filing articles of incorporation. I'm going to be throwing some terms at you with the Secretary of State. Sorry, Professor Ikes, go ahead.
You register an LLC with the Secretary of State because it's a limited liability company. If you're an incorporation, you have to register your articles of incorporation with the Secretary of State. So a little bit of distinction there. LLCs are pretty easy. As Thomas said, frankly, the Secretary of State in Vermont has what everybody knows, a wizard, right? And it just means you basically go to their website, you type in everything it says, and you pay the money, and it spits out a thing that says you're a company now, right? So, I mean, literally, it's that easy. It's when you get into things like an operating agreement and there's multiple parties that you want to bring a lawyer in. Frankly, when it's a sole proprietor that's becoming an LLC to prevent liability, you can go through and do the LLC filing yourself, and then go to the attorney and say, how do I make sure that I don't continue my bad ways of commingling things that I had when I was a sole proprietor? And the lawyer will help you sort of separate that. An accountant can be very helpful in that as well.
And I'll also just say, oh, I apologize. Go ahead.
Yeah. So my question is, like, I want to start, those little food truck on the streets, selling food, but not like a restaurant type of thing, but that's what I'm trying to get into. So do I still need LLC for that, or just a regular license to be selling food on the street?
So we can't give you direct legal advice, but what we can say is that many people with food trucks have LLCs, right? Okay. And it's a comfortable place to be because it provides a liability shield. And folks that sell food are concerned with liability shields because there can be a risk if a food is tainted, if somebody gets injured.
And I'll also drop my email into the chat. So in addition to working with Vermont Small Business Law Center, We also can provide you some other directions, Elam, in terms of what other resources are available for you, including like potential funding opportunities. So I'll make sure to put that into the chat so that you have it.
Okay, thank you.
And
And well-
certainly great opportunities for you to follow up and use that 10 hours of free legal service to get what you need.
And I did
Go
want to
ahead,
say,
Thomas.
I think, Elam, that I heard a question about permits. We'll say, and this is just generally speaking, many LLCs or small businesses engaged in specific sectors like food service might be expected by the state or according to a federal regulation to, as far as compliance, have certain permits or certain licenses. And that's just going to be generally true for certain like food service, food safety sort of thing. So always be aware of in your specific sector, the license, the permits and other things that you have to do to make sure that you're operating within the laws and regulations of both the state and the nation.
And a common thing to think about here is we all know that you need to be licensed to sell alcohol, right? If you open a bar. So like that, there are sometimes regulations. There might be regulations for somebody who had a mobile food cart about where they could park the mobile food cart, for example, or where they could be when they sell it. They might have to get special permission or special licenses to do that. And that's going to be related to the town you're in and going into a city hall and literally just asking the clerk, what do I need to do? And you can do a similar process. And go to a lawyer, yes, but I want to empower you to do these things too for yourself. So don't hesitate to call the Secretary of State's office. In Vermont, we are really good about having conversations about these things. They want to enable business and commerce in the state, not disable it. So they're going to get you the right people and get you to the right organization or agency to help you get your any kind of licensing issue taken care of.
Yeah, great. So
Oh,
is there
thank
like
you for the
a
question.
website or?
I'll send the resources out to you after this meeting, actually.
Okay.
So everything will be in an email, including this PowerPoint presentation.
Great, thank you.
And Wei, if we mention something, please come back to us if you're not sure what we're talking about and ask for the link, because certainly the Secretary
yeah.
of State's website and the agencies and the town zoning, we can get people in touch
Yeah.
with the right folks.
Absolutely. That's fabulous. Yeah. We'll
And thank
follow the
you for the
pictures.
question. Sorry, go ahead, Willie. I'm sorry, I'm real bad about talking over people. I apologize. And once again, just want to say thank you for the question, Elam. I really, anybody else, feel free to jump in, and I'll try not to talk over you because I'm bad about that. Not another mistake we commonly see, and this ties back to the limited liability corporation. So one of the things that it's not required in the state of Vermont to have an operating agreement to form a limited liability corporation. However, it's a good idea. An operating agreement, I'm sorry, is just another type of contract. It's basically designed to structure the limited liability corporation and to spell out who is occupying what position, what their responsibilities are, where the assets belong, who's making what, who's doing what. It really just is kind of a point-by-point handbook to the operation of that specific LLC. So the clearer it is, the more you can rely upon it, just to maintain a good operating understanding of the specific nuts and bolts of that business. So if you don't have a good operating agreement, it can be a liability for a limited liability corporation if there is a disagreement internally about what the company is, what it's supposed to do, or who is supposed to make what or do what. And I think, there we go. Most important things to include in a contract when writing one yourself. So these are just some considerations, things to think about if you're going to go ahead and start working on a contract. Attorney's fees, for example, would be, this is to say, if there is a lawsuit, say somebody sues your company for having done, for a breach or for maybe producing a product that injured them or something, but you feel like your business did not do this. The attorney's fees clause or section of a contract can say that if you win that case, you will no longer be liable for the cost of the lawsuit, such that the other person who brought the lawsuit will then have to cover all the attorney's fees. Unfortunately, one of the things we do know is that attorney's fees can be somewhat expensive, and going through court can be a timely process. So this is all, it's just a good idea to kind of spell it out in advance, and sometimes that can actually be a deterrent to a lawsuit. I don't know if, Professor Ikes, did you want to add anything to that?
I would just throw in that this is to double down on the get an insurance company and have a good general liability insurance plan so that the insurance company can cover the attorney fees and all of the kinds of disputes on your behalf. And you don't have to think about it.
Question, is that also another webinar that we can do about general liability?
I mean, liability is a big topic.
Liability is the topic, and it's important to think about, anytime you can avoid as a small business by having a good insurance plan, and maybe that's your webinar is business insurance and
Okay.
how to provide good business insurance and what that means and what it does for the business owner. It's really important. That's all, just
Yeah.
really important.
And I imagine that, Jay, I think you're on here, working with dogs and owners of dogs, you might want to have something to protect yourself. So I do think, now that you're saying liabilities and insurance, I think that is our legal topic for April. So keep an eye out, everyone, for that, for the date of that webinar.
So another consideration, once again, excellent question, indemnification. See, I struggle even to say it. Indemnification, which amounts to hold harmless. So a good example here, we can go back to the folding chair. Say you have a manufacturer's contract with a manufacturer. It says one of the things you stipulate is these folding chairs should be made of steel, and you get a batch made of wood. Once again, the 90-pound person sits down in the chair, gets injured, the chair breaks. One of the things the indemnification clause in a contract could say is that if there's a material defect in the manufacturing process, the person who's selling the chair and or ordered the chairs would not be liable for the legal process in which the person who was injured tries to go about getting some compensation for that injury.
The manufacturer would be liable, not the person whose idea it was to create.
Yes.
Yeah.
So basically, you can just step out of the whole process, be held harmless, and it'll just bypass you. That's all that means. And it's a wonderful thing to have in those specific instances in which basically you didn't create the problem, in which case you shouldn't be held responsible for it.
You see indemnification sometimes in logistic chains.
Hmm.
So where somebody is creating the pizza dough, somebody else is baking the pizza, somebody else is serving the pizza, and the pizza was served too hot and burned somebody. Well, it's not the responsibility of the person that made the dough, and therefore they should be indemnified.
Yeah, you see it in insurance too. I'm not going to complicate the issue too much right now, but we talked about earlier procedure for disasters, including floods. This was that force majeure clause that we talked about. Just something to think about, another level of protection you can include in the contract, really, because you shouldn't be on the hook for things that were beyond your control, and acts of God are kind of, they eclipse us all. Dispute resolution and or alternative dispute resolution. This is something that you frequently see in contracts, like say with an insurance company, or no, say like your phone provider. If your phone provider says, "Oh, okay, before you sue us, you're agreeing when you sign this contract to first go to a third party and allow that third party to go through either a mediation or an arbitration process." But once again, and this is something that we feel like should be stressed, before you get to that point, have the conversation. Really try to see if you can get back to the same page with the people before you involve a third party. It might very well end up saving you a lot of time, save the relationship, save a lot of money. If you do feel strongly that before you end up in court, you want to pursue some of these, which can be themselves more time saving and more money saving than going through a legal process in court, you can stick a clause requiring alternative dispute resolution before getting to court into contracts that you make.
And I flew out the possibility of a church elder, for example. You can actually specify things like that in a contract, an agreed upon name of a third party who would moderate a dispute or something of that nature. So this can be, contracts are about the people involved and putting down things that you can agree to in advance to stop you from having conflicts. And you can do creative things like that in a contract, and it will be upheld by the law.
The important thing is, so they're flexible, that if people agree to it, the court's going to try to honor it.
That's right.
So another, and the section on the right-hand side of the screen that you're seeing here, this is going to come back to one of the things we referenced earlier as far as developing the good mental habit of almost the like muscle memory of just doing this every time. When you're signing for your business, sign as the business. When you're signing as the person, sign as the person. So maintaining that separation between the business owner and the business.
Can you
So
explain what that looks like, Thomas?
I absolutely can. Oh, avoid personal guarantees real quick. Just want to say that. But so what it looks like is, actually, can you help me out with this, Professor Ikes? As soon as you asked me that, I kind of flew out of my head what I was going to say.
Well, right below.
So when you see the XYZ, that's going to be the business name. And then you want it to say afterwards, LLC, if in fact you are an LLC. And then there's the line, the signature line you're going to sign. And then afterwards, you want to clarify who you are and what your role is. So your affiliation with the entity. So how you're connected to the business organization and what your specific title or role is within the organization as well.
And you're speaking on behalf of the entity. You're acting as an agent of the entity.
Yeah.
You are not saying this as yourself.
Yeah.
And you're not pledging your house to cover this. You are pledging the business's assets to cover this. And it's very different.
So go ahead.
In this case, so like if I had a business,
Mhm.
I would be like, okay, there's a poster here that says Tuesday Tea, so I'm just going to use that. So if I had a business named Tuesday Tea and I'm going into a contract, I would say by Wei Wei Wong, owner of Tuesday Tea.
Correct.
Is that right?
Correct.
Okay.
And better yet, owner of Tuesday Tea, LLC.
LLC.
And
Even
use
better.
the legal name and not your, and this is something we can talk about with an entity formation piece, but not your what's called doing business as. So not your trade name. You want to put your legal name in there.
So whatever is put onto the secretary, like when you're registering with the Secretary of State,
Right.
that is the name that you're putting on, because you also have, as you're all doing this, and some of you may have already done this, there's the formal name and then some doing business as options at the bottom. And so you're not putting the optional names.
Correct.
That
You're using your legal name.
Yeah. So even if like, so if my LLC is Tuesday Tea LLC and I'm also doing business as like W cubed, I'm not putting W cubed on any legal documents. I'm putting Tuesday Tea LLC.
Exactly.
Mhm.
Exactly. And it's just like, my grandfather used to call me green jeans. Don't ask. It's a weird thing. And I wouldn't sign my loan document green jeans. I would sign it Jeannie X, right? So it's like a nickname, right? And you don't sign a formal document with your nickname.
And I want to, because I kind of just said or tried to shoehorn in avoid personal guarantees. I want to go back to that just real quick. What we mean there is if you make promises or guarantees on behalf of your business in your personal life, you will be expected to honor those. So if you want to maintain the separation between so like say you're driving home in your personal vehicle and you get in an accident and you're thinking about your business. And so when somebody says, who's going to be liable for this? What's your insurance information? And you just say, oh, my business information will take it as my business is liable for this. That becomes at that point the case. That would be a personal guarantee. You're saying my business is going to handle this, at which point the business is then liable for it. And it goes vice versa. So if the business does something and then you say, oh yeah, I'll take care of this, then you personally would be liable for what you just said as far as on behalf of the business. It's similar to signing in terms of you want to maintain that strict separation of you as an individual and the legal individual, the entity that's created whenever you make a business, because that's how the law views it, is that business is a person for all intents and purposes at that point. And so you're different people. Professor Ikes, anything to add on that one?
Nope, that sounds
Okay.
good.
So so here we are, this is what hopefully directly affects the people on this call, what to do in creative arts, what contracts, things to know about. So as we were already talking about earlier, as far as intellectual property and licensing, licenses to use someone else's IP or let someone use yours. Licenses are just a good method to allow you to allow other people, multiple other peoples, to use the same creative work and for you to profit from it. And then this flip side of that coin is you want to make sure if you're using somebody else's intellectual property that you have a license so that you're not liable for effectively infringing upon somebody else's, or unauthorized use of somebody else's intellectual property.
We'll use the web design example here. People often grab art or images from some other website or some other thing. You have to get permission and pay any royalty fees that are necessary to use those images and other things. And that's the flip side of that. You can't assert that you own something that you indeed do not own, nor can you resell it and profit from the resale of that without giving the originator some cut of the deal.
It's just about honoring the person whose effort brought this creation into the world. Speaking of which, sometimes some of these creative products enter the world because somebody hired an artist or other artisan or craftsperson to create them. So when we say work for hire unless modified by contract, employer, commission of work of author, is basically what we're trying to say here is that if somebody hires an artist to create a specific piece of art, the finished product belongs to the person who commissioned it and not the artist. That being said, one of the things you sometimes see in contracts, especially for artists, would be a section that says this is not work for hire. And effectively what that does is establish that the artist isn't selling all the rights. They're saying, I still maintain some interest in this property and still can profit from it in some way, shape, or form, some of which will be actually clarified in the contract structure itself. The next one is a fun one: registering collections of work for copyright protection. I'm going to use the example that we talked about earlier. So let's say you write a 200-page book. It's effectively just a collection of pages. You could go through the process of registering each page, which would be expensive. Let's say it's $20 a page. You can see how quickly that would add up. One of the things you can do, however, one of the and the forward-thinking people at the Copyright Office did was allow you to register a collection of works. Now there are going to be, I imagine, some things specific to what can fit in a collection. You can't just sell a collection of different things from around your house as a collection of furniture. If it's like movies or a dog and other things, you want to make sure it's cohesive to some degree. And there are we can provide specifics there, but basically the idea is you can register things as a collection. It'll save you money. And it's a good thing to do if you qualify.
Each time you register a page, you might pay $20. Right. If you put the whole novel in, all 200 pages, and called it a novel, that would be a collection, and it would be you registered the novel for $20 instead.
Yeah. Yeah, I didn't get to that piece where I explained that it was just cheaper to do it as a collection, but thank you. Some designs might be patentable. This is basically going to be how novel is it, how innovative is what you're doing as far as the design. Patentability is another form of intellectual property that basically, like the folding chair, if you figured out a new way to make a folding chair, that design might be patentable. If it's an existing model of a folding chair, that's going to be that probably won't be patentable. Somebody probably already has a patent on it. And it's already out there. So as far as some designs might be patentable, you want to look for, have you discovered a new way to do it? Something that's nobody else has thought of? Did you improve the process or the design? Is there something there that's unique to your creative production that you brought in the world that you can defend? take advantage of trademark if you can. So trademark is going to be, like a brand thing. If you think about trademark, think about if your business does something in a specific, so let's say you design websites, and your websites, when people see them, they know off the, oh, Jay has a question. It's all raised hand.
Yes, sorry. This is a little, I think, on topic. So I'm also a creative, and thinking about this, especially when it comes to like possibilities of fair use or what could be a violation of a copyright or anything like that, for someone who sells collages, this is something that I'm really concerned about, because like if I'm cutting out of a Vogue, like these are works that people have been paid for and that sort of thing, or even the 7 days, like what, if it's too specific the answer, that's fine, but like what sort of things would be needed for that?
It is specific. It's also a changing area of law. You may or may not have heard stories about artificial intelligence using different pieces of artwork to create new artwork. And there is a whole lot of law being created here now. So your collage question is almost a perfect example of what AI is doing with technology. And it's really, okay, sorry, law professor hat. That's fascinating question.
That's good.
And what I would say is you could think about it as pulling together an assortment of things, as long as you didn't use too many of. It's going to depend a lot on the size and the proportion and how much of them you use and whether or not you're crediting people when you use them. There's going to be a lot of stuff there. You should talk to a lawyer because it becomes very specific very quickly as to what you're doing and how you're doing it. Also, for example, people who create collages will often use things that are no longer protected by copyright. They're out of copyright. So you can get really old magazines, old National Geographics, and hey, they're not copyrighted anymore. And you can use all of that stuff to create your collages. So there are a lot of different issues there and a lot of things and it's worth a half an hour with an IP attorney would really set you straight on that.
And there's a great one who is part of the law school. So
Brian Bailey would be.
So yeah, get in touch with the law school, because yeah, this is something that you know, we as an organization have also been careful about. You know, we did an event with Wakanda Forever, did not want to use that imagery from Marvel because did not want to get sued. No. So we had to create our own imagery for the event. But also like thinking about Creative Commons, sometimes they're not so like open as well. So some of those copyrights for those items.
Sometimes it'll matter, sometimes it won't. Yeah. Sometimes when you cut things up and you use them for a different purpose and a new artistic endeavor, there are some ways around some of the copyright and the exclusions, but you got to be really careful and you got to talk to a copyright / IP attorney for that, because it's going to have a lot of, it's going to be like a maze, and following the maze to make sure that you meet all of the different aspects that are required by law.
Yeah.
And just a heads up for folks here, thinking outside of even that more formal creative space that Jay is talking about, when you're using images for your website, be careful, because you could get a copyright infringement like fine for using certain images. So so we had someone on the board previously who had recommended, if you are going to be putting images, get a subscription to a stock photo site so that you're not using someone else's work. So
or take the pictures yourself, you know, that's exactly. The other possibility.
Exactly. Yeah. Thanks for that question, Jay. That was great.
That was a great question and really exciting for the law professor and me. So there you go.
No, that was a fun question. I would say it was enjoyable listening to the answer. Um, take advantage of trademark if you can. Where was it? Oh, so let's say you create a website, um, and or your business is known for creating wedding websites, and people who look at them can just from looking at them identify them as belonging to this specific site. It's just so recognizable, it's so unique, your style. If somebody else were to come along and then try to imitate that style and put it forward to the public as belonging to this specific website in order to basically profit off of the unique style, that could be an infringement of trademark or how you go about doing business. think
Usually,
Professor
though,
X is-
what we see with
Yeah.
trademark is more specificity. Trademark is going to be your name, it's going to be your logo,
Mhm.
it's going to be things that are identifiable as you. Also, it's sometimes a slogan, right?
Mhm. Branding.
Best.
Like Nike or something like that. Like
Yeah, just do it.
Yeah.
Just do it would be a trademark, right, of Nike. And when you get into doing those pieces, you can trademark something just by putting the TM on it, or you can register the trademark, which is a much longer, more involved process with the federal government. When you do the little TM, what you're saying is registered trademark pending, that you're trying to go through the process to register your trademark. And that asserts, it tells the rest of the world, hey, I'm using this, but I'm also registering it.
So I don't want to go into the weeds on this, but what is the difference between getting something patented and versus licensed versus copyrighted? Is there something-
Copyright attaches to artistic works of expression. And automatically. So the written word, art, however, as soon as you create it, it is copyrighted. Patent is usually a mechanical or way of doing something that is specific. It is engineered usually, and it involves a schematic and other things that you send to the USPTO. It goes through like an 18-month period where it's hidden from everyone else and it's kept secret and only the USPTO knows about it. And then if they give you the patent, you can go ahead and use it and it will be recognized as your idea, and anyone else who does that thing has to pay you for the use of the idea. The chair, a better way to create a folding chair is a patentable design plan, right? Or mechanical idea, right? Those biscuit cans where you hit them and they come open. And you ever seen the biscuit cans in the
round
grocery
rolls.
store? The round
Yeah,
rolls,
the cardboard with the metal
yeah,
on
yeah,
the
yeah,
cardboard.
yeah, yes.
And then
it pops.
So
That's the one.
a great uncle of mine had the patent for the biscuit can, right? And he got a penny for every biscuit can that was sold.
I'm sorry, what? That's a lot of biscuit cans.
Yes,
it's a heck of a lot of biscuit cans. It's a crazy amount of money. And that's why patents are so important, is because you license the idea and everyone that uses it, and everyone uses biscuit cans that work that way. There hasn't been another idea to replace it.
Yeah.
Hmm.
And so
he made his fortune. He made his fortune literally.
So it's a physical item for a patent.
Almost always. It can occasionally be a design item. For example, Apple owns, God, I don't know how they manage this. They own the capacity to make rounded corners on cell phones.
Right.
They
That's
had good
interesting.
lawyers. That's all I have to say about that. They had really good lawyers. And they beat Samsung, and Samsung has to pay them for using the certain curved way of curving the phone. So that's what a patent is, and that's how patents work. And they're distinctive from copyright because they're not an artistic expression. It's that's very brief, and Brian would probably just his eyes and scream if he heard me I have minimized it a whole lot. It's much more complicated than this. All right.
Don't worry, we won't send
so
this recording.
bring Brian in to really give you the skinny on this and not me. This is not my area of expertise. I know enough to be dangerous, as they say. So what I would do is move on to the estate planning with an LLC, Thomas.
Not a problem. I was actually just gonna say, also not my area of expertise, so I appreciate all of your putting up with me on this slide. Consider estate planning with a limited liability corporation. Just another thing you can do. Another way you can use a limited liability corporation is kind of like an asset protection, a succession planning instrument. So if you have children and you want to make sure that they end up running the business or they end up with something if something happens to you, this is another protection that an LLC or starting an LLC can confer or provide you with.
When we talk about generational wealth and passing generational wealth in this country, one of the ways it has long been done by the exceptionally rich is they create a company and they put their assets in the company and then they add their children to the company. And so because entities exist after a person who formed them dies, they are their own being. And they do not end until the parties involved in the company end them intentionally, right? Or it's so written in the operating agreement that if all of the founders die, then the entity ends. But most are not written that way. Most are written to continue at the death of the founder so that the parties that are involved or have invested in the LLC can continue on with that business and continue to run it and can continue to see revenue stream. So it's a huge and tremendous estate planning asset. And it's a way to move assets to the next generation without paying a lot of taxes on them.
We're getting some gold here, folks. That's awesome.
So I have a question about what she just said.
Mhm.
So so how does somebody go about adding their kids to their business and for them to build like a wealth for them so they can grow up and have something?
You would add, so LLCs can have members and you can, by vote of the members, increase the shares available to each member. And so in a family held LLC, you just say that, oh yeah, so-and-so gets added and we give them a share of the LLC and they're now a member. There are some accounting issues involved in that. And you have to be careful with how you do it. But with proper financial guidance, you can do that very easily.
Because also I'm seeing on the internet people hiring their kids in their business and creating like a rough area or something for them.
Absolutely.
Oh. Mm-hmm.
Okay.
There is no reason that parents can't hire their children and pay them.
And do they have to be a certain age or it can?
Well, that's a great question. Yes, there are labor laws. Generally in family businesses, there are exceptions for labor laws, particularly in family farms. That has to be looked at it on an individual case-by-case basis, and it generally has to do with whether or not the child would be endangered engaging in those work environments.
And I don't want to get too in the weeds on a Roth IRA, but it's just a savings retirement instrument, individual retirement account. It could be separate from a business. I don't know too much about them. I will just say, as far as I know, they're a really good idea and a good instrument for saving for the future.
Yep.
So don't count on fair use. Oh, and Elam, did we answer your question?
Yes, you did.
Okay. And I hope I didn't mispronounce your name. I apologize if I did. So don't count on fair use protection for using others' work. Basically, this kind of goes back to the licenses that we were talking about earlier. You should not bank upon without asking or consulting or just doing a little research. The idea that you're using somebody else, fair use protection. Yeah, that you're using somebody else's and it's going to be okay. Don't just assume something is going to be fair use and that you could just willy-nilly appropriate.
And this is exactly what Weiwei was mentioning earlier about making sure you get a subscription at the Stock Art images if you're going
Mhm.
to put those images on your website, right?
Yeah.
This is what we were talking about, is that kind of fair use.
Yeah, it can be broad. I think, like, for example, there's a whole body of law about sampling, as far as I know, for like music, which is going to be, yeah. But so when in doubt, do a little bit of research and try to make sure that you're on the right side of using other people's intellectual property.
There are
My
some Queen songs out there that were used by Ice Baby. Is that how it started? And
yes, Vanilla Ice.
Vanilla Ice and Queen, and a whole dispute about sampling. So yeah, don't go there. Don't do that. Make sure you're paying somebody for the use of their intellectual property.
Mind the scope and the IP. Professor Ikes, I know earlier, could you cover this one for me?
We talked about this. So
Uh,
when you start out to do a piece of work,
Yes.
don't give people bonuses.
Yes.
Get paid for the bonuses, folks. So you've got this again, Thomas, or do you want me to handle it the rest of the way?
No, I think so. Yeah, I took me a second to recall. So the example I was thinking of earlier is, like, say an artist is hired to create a sculpture for somebody's lawn. They go about creating it. They love the way it looks, but then they suddenly decide, you know what this really needs? A reflecting pool. It'll really just enhance the beauty of it. You'll be able to see it in the water. It's going to be great, but it's nowhere in the contract. The people who commissioned the statue that's going to be reflected in the reflecting pool that suddenly the artist feels needs to be there has never mentioned this. It's not in anything. At the point where you move beyond what was commissioned and beyond what was agreed upon that was going to be created, and you start adding to, everything you add to is not protected. Everything you add to is going to be in addition. So if you had, say, a work for hire, this is not work for hire. Basically, when you start straying, you start creating complication. If you stay within the confines of the contract. So
in Thomas's example, you had a sculpture, right?
Mhm.
And that was what you did, but what you ended up giving them was an artistic installation, which is a little different if you add the reflecting pool. And so you could have charged them for the entire thing and had IP for the entire thing had you sold it that way originally, but you didn't, and you just gave them bonus add-on that you didn't hold the rights to. If you go outside the scope of your original agreement. So watch your scope.
Yeah. Anything you throw in, unless it's in the contract already, you're just doing for free.
It really is a freebie, and furthermore, you can never say, "Hey, that's mine. I did this."
And for the next point, mind indemnity if you're working with the manufacturer. We talked about indemnity clauses already to a degree. Basically, just saying if something is different than what you had contracted with for the manufacturer, or if there's a problem, what have you, that doesn't stem from or originate with the person who is contracting with the manufacturer, the indemnity clause says the manufacturer is liable at that point for any problems that are different from, which would be kind of minding the scope. I don't know if I explained that all well, but we kind of talked about it earlier.
The indemnity piece is about making sure that you're not getting blamed for a poorly made chair when you're only contributing the design and somebody uses inferior materials to create the chair.
Yes. And so the next part, creative industry is broad, is basically just kind of also talking about the idea that if you are, say, involved in publishing, you're going to need different contractual language, different things in your contract than, let's say, you're getting into for advertising. So what we talked about, let me simplify this. If you're hired to film an advertisement for a business, and in the process of creating that advertisement, you create a mascot. The contract that you provided is going to basically say that that advertisement is what you were hired to produce. So you can't charge for the production of the mascot. What you're doing is producing the advertisement. If you were hired, let's say, to produce a mascot for a corporation, then you could charge for that. So depending on what you're doing, like let's say everything goes into creating creative.
The contractual obligations around that may be different, right? The advertising looks different than when you've done something that was creating fashion for them.
Yeah.
Right. And so the specifics to those types of contracts are all a little bit different. And you
Hmm.
want to be sensitive to how they could be different.
There are many different types of creative industry, and you just want to, once again, you can defer to industry groups to kind of get best practices or model, but you want to make sure that the contract you have is specific to your industry and covers the creative output that you have, so that you're being correctly compensated for what you produce. Okay.
Perfect.
How can a business ensure it protects itself? So we've gone over a few of these already, so I'll kind of try to keep it brief. Have an entity, create a business, allow the law to help you to create that other person in terms of the entity that can take all the legal liability lumps, as it were, and create that protection for your assets so that your house, your car, anything that doesn't belong to the business can't be touched by anything that goes south if the business suffers legal jeopardy.
A sole proprietorship is not an entity, it is you.
Yes. Which is, if you start doing business without doing anything to form an entity, that is the default state for a business until you take steps to protect yourself with some other type of business entity or structure. If you form an LLC, have an operating agreement. Once again, it's not required in Vermont. It's just a really good idea. Some states require them because it just helps those who are a member of an LLC to, it's just another contract. So just to be on the same page and have that meeting of the minds. Sign for your entity if possible. So you always want to make sure that you don't mistakenly sign a check on behalf of the business in your personal guise, or I guess your personal identity, and you don't want to sign anything on the personal side on behalf of the business. Just get in a good habit of making sure that you're paying attention to what you sign and for whom, so you don't mix assets.
Kind of goes without saying, but don't write checks out of your personal account to pay for business assets, and vice versa. Don't write checks to your person to pay for personal things out of your business checkbook. Right? That's a simple way to think about what we're trying to say here. Keep them separate.
It just creates an accounting nightmare, or can, and it can also
can
breach
you can incur liability.
Yeah.
Because you've done that.
You can defeat the protections the LLC was designed to give you by doing that, and so
because you're commingling.
Protect your intellectual property. So we talked about this earlier. Intellectual property is an asset. When you create it, it's worth something. So you just want to take the steps to make sure that nobody else can profit off of it without your permission, and that you're the only one basically who profits off it in the way that you want to, unless it's work for hire. If it's a commission piece, that's different. But either way, if you can take steps to protect something that's of value to you that you created, do so. Include the right things in a contract. Know when it's fine to not have one or to have a simple one. So once again, if you buy a bike off of somebody off of Craigslist, you probably don't need a contract, or if you do, you certainly don't need a 100-page contract. If you're working with a lawyer, and let's say you have a standard website design where your standard website is like 15 pages, and then somebody says, I need like a 5-page one. You could probably use that same contract. You might need to tailor a little bit, but you certainly don't need something much more complicated.
Nor do you need to go to your lawyer every time you need a new contract.
Exactly.
It should be a general contract. You should be able to amend it in certain ways, and it should cover the services you offer. Be clear with your attorney when you first talk to them that that's the kind of agreement you want created, so that you can make the additions, add, and subtract as necessary. Lawyers don't anticipate that you're going to go back to them every time. They should be writing what we think of as an evergreen contract or agreement. And unless you radically change your services, you should be able to just include the scope and cover yourself.
Yeah, I kind of muddied what I meant to say there, but another thing to say, speaking of services, is when you're contracting with a lawyer for a contract, that is a service. So always you should feel comfortable, and I want to, as far as empowerment, encourage you to ask questions of the lawyers that are helping with these to make sure it fits your needs, but to like push back if, say, a lawyer comes back to you with a 100-page contract when in
For a
your
4-page web design.
for a 4-page web design. That is probably going to be an instance of billing for hours, where you're being charged for something you did not need. And if you feel like that's the case, it's okay to ask questions about that.
It's okay to say no when I'm not paying you.
Absolutely.
Forget that. It's fine to say to the lawyer, no,
Let's see, insurance. Oh, once again, this is another thing that we really like to encourage all business owners to have. It's just another level of protection, asset protection for your business and for you, to help make sure that you're not on the hook if something necessarily goes bad. Insurance companies are big entities. They have, generally speaking, a lot of lawyers, and it's a really good idea to pay them to go and fight on your behalf so that you don't have to pay monies that you're not liable for. Or if there is a liability, your insurance company will cover it so that you're not on the hook for it. It's just a good thing to do. Let's see. Anything you want to add to that one, Professor X? Because I know
Yep.
We love insurance.
We do. Insurance good.
Also, keep in mind, working from home, town zoning, some of this, the running a business on property bigger than 1 acre, Act 250. I'm not going to go into too much of the specifics of. I'm going to try to boil it down to just say, talk to the people in your area. Once again, a lot of contract is about preserving relationships. If you work things out with people in your area prior to like doing something new on your land affiliated with your business, it's probably a good idea. So let's say you're a sculpture artist, because we like the sculpture example, and the next door piece of property has a church on it, and somebody contracts that sculpture artist to start sculpting nudes. That might be an issue for the church, but it might be something you can also handle beforehand by just saying, let's have a conversation with this or about this, and figuring out what's going to be an acceptable arrangement for everybody. That way you're not going to be running afoul of zoning ordinances or requirements. Always a good idea to investigate zoning requirements related to your businesses beforehand to make sure, like, let's say you decide you want to open a farm in the middle of downtown, that's going to be an acceptable use of that land, and then you're not running afoul of the land being zoned for something else. Let's see. The Residential Construction Contractors Act is something. Oh, let me go back up. That's a relatively new thing. I think we're gonna provide information about that. Did you have a chance, Professor Ikes, to look into that?
We are going to provide information about that.
Okay.
It's a new piece.
Yeah, this is a relatively new phenomenon. I think it's and I figured exactly what it does, but we'll get you information about that for anyone interested to make sure that you understand the compliance necessary to engage with the Residential Construction Contractors Act. Now, consider S-Corp taxation is something I was going to throw to Professor X.
All right. Consider S-Corp taxation. Why there's a difference between being treated. So let's go back a step. LLCs and S corporations can choose how they want to be taxed. You can either do what's called pass-through income, or you can hold the income in the corporation. If you do pass-through income under Trump's tax cuts, you get a 20% off the top of your income. That's basically free income and not taxed. It's quite the deal for entrepreneurs and business owners. It only lasts through 2025. So when you're deciding whether or not you want to be taxed as an S Corp or you want to be taxed as an individual, you need to spend some time with an accountant and get all of those numbers square. Lawyers are not accountants, but often it can be good to have your accountant in the room with your lawyer when you're being advised. Otherwise, they can say things that sound like they're conflicting. And it's better to have them both in the same place at the same time. Even if it costs you a half an hour of your accountant's time, it's well worth having everybody in the room to have those conversations so you can square away anything that sounds like a tax versus legality conflict and get that squared away. So when we're considering S Corp taxation, that's one of those times to have the attorney and the accountant in the room and deal with your personal considerations one-on-one. And we talked a little bit about registering collections of work for copyright protection.
Yes, we did. Okay, and it is Professor Ikes.
So I'm gonna kind of wrap up before we go into the questions by saying that we are the Vermont Small Business Law Center. And we are happy to be of service to the Vermont community. We offer free legal education consults with the Small Business Law Clinic. So if you haven't heard enough of us talking at you for 2 hours here today, we can talk to you some more in a more directed one-on-one way to answer more questions you have. So if you have intellectual property questions that are burning about, say, collages, you can certainly call us up and register for one of those educational sessions and talk to Professor Bailey about IP law. So we do that and provide educational consults. Once you've gone through an educational consult, we'll refer you to an attorney for 10 hours of up to 10 hours of free legal service. And we have all kinds of educational events like this one that we do with VTPOC. We do it with the women's
CWD.
All of the acronym
Connections,
soups.
CVOEO, all over the state, in person and virtual. They're great.
Exactly. So, sign up for an event if you're interested in the subject.
Yeah. Yeah. And they're wonderful because they can also teach you how to talk to a lawyer. You saw some of that today, and I remember over the last 2 years, there were a lot of like webinars on that specifically of like, how do you prepare to talk to a lawyer, getting your questions prepared. So definitely take advantage of that opportunity. Whether you're starting a business, about like, oh, what is legal structure? What are those legal structures? What do they mean? Talking about S Corp, it's like, what is the difference between a C Corp and an S Corp? Because that's a lot of like, once you go down that, Elam, thinking about you starting your business, like, how do you make those decisions as you're starting to look into those various like,
And sometimes it's so much unknown when you start talking about law that you don't even know what questions to ask.
Exactly.
And the idea of our educational consults and these events like this one today are to give you an idea of what questions to ask a lawyer, so you don't spend half of your bill for time getting educated about what you should have asked.
Yeah.
We want to help you get to the place where you can ask those questions directly.
Speaking of questions, do folks on the call have any questions for the two fabulous experts here? And feel free to put it into the chat. Also,
Absolutely.
if you're, for some reason, you can DM me directly and I'll keep your name out of it if it feels uncomfortable. So, and I'll also say, like, as we're waiting for questions to come in, and please just unmute yourself if you do have a question. We are going to hold, the plan currently is to hold monthly webinars from VTPOC and the Vermont Small Business Law Center. So if you do have specific topics that you'd like us to talk about, please let me know. I'll send a follow-up email with some of these resources that Professor Ikes and Thomas have talked about, as well as the PowerPoint presentation. So, and there will also be an evaluation survey with that. So I will be asking if you want to hear different topics, if you would like the format to be changed. Happy to consider all of it because this is a newer webinar series that we've started. So any questions for the folks here?
I've got a question. Wait, would you like me to stop sharing the
Yeah, please stop sharing. That'd be great.
Okay.
Thanks. Because it's on a separate screen for me. So And with the email that I send, I'll send a link to the Small Business Law Center website and also the intake form that they have so that you can get immediately connected if you want to for that. And just a question for you all for use of the educational sessions. Can you be a solopreneur? Can you be like a sole proprietor? Like you don't have to have
Oh,
formal
absolutely.
setup.
Absolutely.
Great.
We do folks before they've even gotten to the setup stage, right?
Yeah.
Where they're
Yeah.
still thinking about it
Mhm.
and they're just trying to, for example, we talked to somebody the other day who was trying to decide whether they were for profit or they were nonprofit, right? And they just wanted to understand the legalities around that a little bit more.
Mhm. So question in the chat, is it necessary to consult a lawyer for writing a terms of service or privacy policy on a website?
That's a great question. Data privacy is one of my wheelhouses. It can be tricky depending. If all you're going to do is promise that you're not holding anybody's data, it's pretty easy. If, on the other hand, you have specific ways you'd like to use people's data, it starts to get complicated pretty quickly because you have to comply with state law, you have to comply with federal law, and you have to comply with some international laws because websites are by their nature international. So privacy policies can be complex. There are ways to narrow that, and there are certainly good services that you can get from professional organizations that can suggest privacy policies. But yeah, a half an hour with an attorney on that one is very helpful. Terms of service for a website, you don't need to consult the lawyer for your terms of service. You can probably put it down. But again, having them look over it once you write it is a good way to spend part of that 10 hours. Keeps you out of trouble.
Another question, do you have any general advice on creating a contract when setting up a barter system / service for service exchange? That's a great question. Like, so for example, if I were to create a website for you, Professor Ikes, and you were providing, I don't want to say legal services, but
Yeah, but that's fine.
Yeah.
But that's fine, right? The running joke among Vermont attorneys is we provide legal services for eggs every week. You know, if somebody gives us a dozen eggs every week, you know, you get legal services.
honestly,
So
eggs are expensive. So yes.
eggs are really expensive. So there you go. And you know, good organic farm raised eggs are extraordinarily expensive. So there you go. But yes, a lot of that sort of trade and barter happens, particularly you see it in Vermont more than I see it in other places because there's a lot of cottage industry in Vermont. So setting up a contract when dealing with a barter system or service exchange, write it down. Again, just like you would any other contract, it's just what we call legally consideration changes, right? So your consideration is eggs, or your consideration is legal services, or whatever. And so what you're paying changes, but otherwise it's the same as a standard contract.
Do you, for something like that, let's say someone's creating a website for me in exchange, can you put out like a dollar value on that? It's like creating a website up to X value or with a minimum of X value.
Yeah, but I wouldn't use money for that
Oh,
because
okay.
a service, I would scope it.
Yeah.
I would scope it very carefully because
Hmm.
otherwise, right, a website could be 5 pages or it could be 200.
Ah, okay.
Be careful.
Okay.
Be
So
careful
they
to
could be,
use
so
a
you could
scope of
say like up to
services.
$4,000, but they're like, oh, but we charge $200 an hour. And so they
Exactly.
could like, yeah, okay. All right.
Yeah. Yeah. So be careful.
Okay.
Be careful if you're creating a contract for bartering or service for service exchange, just make sure you're careful and know what you specify because it's really easy. You see this when one partner in a business puts in sweat equity and the other person invests dollars. You see a lot of dispute over the value of the sweat equity versus the dollars invested. And if I said there's any one thing that causes partnerships to split more than anything else, it's that it's that dichotomy between sweat equity or service input and cash input, and not valuing things the same. So be real careful and explain it very clearly so that everybody's on the same page.
That is really interesting. So in that case, and maybe this gets too deep into it because we're running out of time, but if someone's putting sweat equity into it, would it be helpful to have like an hourly rate and
I
like
would.
an expected like salary per year for that person?
I would
at what
agree
how
to
many
that.
hours are they working?
Absolutely. I'd agree to all of that in advance, because otherwise, it's too hard to quantify later.
Yeah, right, exactly. And then you
Um,
might do more. This is making me want to go to law school. Both of us telling me don't do it because of the cost, but this is really fascinating. So
it can be expensive to do this, right? To figure out how to quantify those various pieces, and you end up in a situation where it's very unbalanced if you aren't careful. I was involved in a sweat equity agreement at one point. I would never ever do that again. Just as a personal aside, it was awful.
Even if you have a contract through it, wow.
Even with a contract, it was hard.
Yeah.
Because how do you get people to perform?
Right. There's no benefit.
Right? Because you've already supplied your piece. So, right? It's go carefully with that. Very carefully.
Nice. Okay.
That's just personal experience. That's not legal advice. That's just be careful when you do it.
Right. Any final, we got 2 minutes left. Any final questions, burning questions? If not, like I said, I'm going to be sending out an email on how you can get in touch with the Vermont Small Business Law Center, and with Nicole Kalorian, Dr. Ikes here, Thomas, and Sean even. I'm guessing that you're with the Small Business Law Center as well in some capacity.
Yes.
So there's some really great folks who work with the Small Business Law Center and really, really helpful. Wide range of experience as well. So,
and we're fortunate to have a connection to the Vermont Bar Association as well, so that if we don't have people already on our staff that can do this, we certainly have connections to folks that can get you to the right lawyer, to the right expert.
Yeah, it's an incredibly valuable service, and so grateful that there are grants out here for the center.
Yes. And we need to continue working on that way. So there you go.
I got you. All
right.
We'll work with Nicole on that. So
absolutely. All right. Take care, everyone.
Yeah. Thank you so much.
And thank you.
Appreciate
thank
the time
you.
and energy.
We so enjoy.
We might see you again in future webinars.
Absolutely.
So again, thank you for your time. Thank you everyone for joining. Look out for an email from me.
Right. Take care, everyone.
Bye.
Have a great day. Bye-bye.
Bye, everybody.